to me, it's a win-win for everybody, because the lawyer that looks at all these cases, now they understand what the issues are. And when it comes to the court, now we as a court understand what the issues are and how different opinions could come from different panels. I'm Richard Brown, and I'm the Chief Judge of the Court of Appeals. We talked today about three things. Whether the Court of Appeals was a law-developing court or an error-correcting court. And then Professor Blinka and I went on to talk about unpublished decisions and its effect. We were organized as an error-correcting court. And as Professor Blinka pointed out, back then there were a lot of trials. There's less and less today, but there were a lot of trials where instructions would be given in one case that would be different in another case, and it was for the Court of Appeals to sift and winnow and correct the errors. Since then, our court has come to the conclusion that yes, we are a law development court, not like the Supreme Court, which sets the policy and tone of the law one way or another, but we do develop the law. My philosophy is Oliver Wendell Holmes' philosophy, which is the law develops interstitially, molecule by molecule, and you get a bunch of molecules together, and then you get a picture like a compound. The law is the same way. When we were in law school, we had a professor who said, I want you to read Smith versus Jones for the next session. Well, the professor didn't want you to read Smith versus Jones. He wanted you to go beyond and look at what the issues are. How would different people look at this issue and decide cases differently? And that's essentially what's happening with unpublished decisions. A panel will see something and they'll look at it and they'll come up with their decision. Another panel will look at it, they'll come up with a different decision. And what that does is it doesn't confuse the lawyer, in my view. It helps the lawyer understand what the issues are and how many different ways it can be decided. And then you can bring that in your brief and show the differences between what the courts are doing. And then hopefully there will be a published decision which will decide what the law is. Eventually, there are cases out there in the public market. Everybody's reading those cases. Some of them may be differing in result than others and rationale. And it's incumbent on our court to find out what the landscape is and write an opinion that resolves the issue. And then the Supreme Court, of course, has the opportunity to review and come up with a different opinion. But to me, it's a win-win for everybody, because the lawyer that looks at all these cases, now they understand what the issues are.